Hi, Harold Associate. Sorry we couldn't meet in person, but due to the coronavirus, this seems a safer way to conduct the settlement talk. In a nutshell, we're confident that fighting Big Bank in court is likely to be a futile effort that will certainly waste your client's money, and here's why I believe that. To begin, the first issue is whether Big Bank's first loan has priority over Katrina's lien. Sorry. Big Bank has a perfected security interest in the equipment. Big Bank's security interest attached on January 1st, 2014 under Section 9203. Attachment occurs when the three requirements for attachment exist. The existence of a security agreement, the debtor has rights in the collateral, and the secured party gave value. Here, the attachment of the security interest to the equipment occurred on January 1st, 2014 because Punk Brew Pub had already owned the equipment, and on that date, the security agreement sufficiently describing the collateral was authenticated and value was given. Big Bank perfected its interest by filing a sufficient financing statement against the debtor in the proper place on December 20th, 2013. Also, it's important to note that under Section 9502D and 9509A1, Big Bank can file the financing statement before the security agreement is made or a security interest attaches because the debtor gave permission in an authenticated record. Big Bank's priority date is December 20th, 2013 because priority relates back to the date of filing under Section 9322A1. Katrina, on the other hand, has a judicial lien on the equipment, which makes Katrina a judgment creditor. The judgment lien was obtained on February 5th, 2018. Article 9 places a lien creditor below a perfected secured creditor having filed before the lien arose. That means that Article 9 makes it clear that Big Bank's first loan has priority over Katrina's lien because Big Bank filed in 2013, which was before Katrina's lien arose in 2018. The second issue is now whether Katrina's lien has priority over the second loan from Big Bank. Big Bank's future advance is secured because the security agreement has a future advance clause. Security interest securing a subsequent advance has the same priority as the security interest securing that first advance. So Big Bank included a future advance clause in its security agreement. So when Big Bank made the second loan, the priority date is still the initial filing date of December 20th, 2013. Katrina's judgment lien arose in February 5th, 2018. Sometimes lien creditors can take priority over the future advance. The rule in 9323B lays out that if a lien creditor provides a perfected secured creditor notice of its lien, and then 45 days later, that secured creditor provides a future advance to the debtor under the terms of a secured transaction predating the lien, then the lien creditor takes priority over the future advance. Here, assuming that Lewis learning of the verdict a week before the judgment lien arose and talking to Harold in late 2017 are considered sufficient notice, let's just say for argument's sake, Big Bank knew of the lien. However, that knowledge doesn't matter because the clock starts ticking the date of the lien. Big Bank granted the secured loan during the grace period. The clock against Big Bank started to run on February 5th, 2018. In 2018, there's only 29 days between the date of the judgment lien and the future advance. The lien creditor only gets priority if the future advance occurs 45 days after the lien is granted. In short, Katrina is subordinated to Big Bank's second loan because Big Bank provided the loan within the grace period provided under Article 9. This means that both Big Bank's loans, totaling $550,000, have priority over Katrina's lien. The $749,000 in collateral is sufficient to pay off the loan. The remaining value of $199,000 should be Katrina's, assuming there's no other secured creditors lurking out there. However, there might be costly non-advance costs that incurred from trying to collect the secured obligation, which is going to reduce Katrina's overall amount. Big Bank's sympathetic to Katrina's harassment while she was employed there. The guy was a jerk. To ensure that Katrina gets every possible cent out of her lawsuit and to avoid litigation, we're willing to waive the collection of the non-advance costs from the collateral's value. So that means Katrina can get that $199,000 without any more courtroom battles, and she knows the price she's getting. I hope this proposal is reasonable to both parties' needs given the law. I look forward to hearing back from you by the end of the week.